Morning. I am Kathleen Thompson, Chair of the Professional Fiduciaries Bureau Advisory Committee. I am calling this meeting to order at 10:05. This meeting is being held on Wednesday, May 29th, August 14th, 2019 at the Department of Consumer Affairs located at 1747 North Market Boulevard, Sacramento, California, 95834. This location is open to the public and accessible according to the American Disabilities Act standards. Item number 2. At this time, I would like to ask Angela to call roll to establish a quorum.
Good morning. So I'm going to go ahead and call the roll. Hangley Doe is absent. Wendy Hatch.
Present.
James Moore.
Present.
King G.
Present.
Kathleen Thompson.
Present.
And with 4 members present, we do have a quorum.
Thank you, Angela. Item number 3. I would like to ask the committee members and Bureau staff to introduce themselves. Can we start from my far right?
I'm Angela Quadra, the Program Analyst for the Bureau.
Fred Chanyu, DCA Legal Affairs.
Rebecca May, Bureau Chief.
Kathleen Thompson, Supervising Court Investigator for Solano County Superior Court.
Wendy Hatch, Private Fiduciary in the Los Angeles County.
James Moore, Private Fiduciary in Sacramento County.
King G, committee member and advocate for seniors in California.
Thank you. Would any members of the public like to introduce themselves? Thank you. Item number 4. Rebecca, please read the Bureau's mission statement.
To protect consumers through licensing, education, and enforcement of the Professional Fiduciaries Act by promoting and upholding competency and ethical standards across the profession.
Any comment from the committee members? To allow the committee sufficient time to conduct its... I'm sorry?
On that item? Okay, sorry.
To allow the committee sufficient time to conduct its full schedule of business, public comments at the end of each agenda item will be limited to 2 minutes apiece. Is there any public comment on this item? Okay. Thank you, Rebecca. Item number 5. Are there any suggested edits to May 29, 2019 meeting minutes from the committee members? Okay. Is there a motion to approve the minutes?
Wendy Hatch, I make a motion to approve the minutes as presented and written.
Thank you. Is there a second to the motion?
Jim Moore, second the motion.
Thank you. Any discussion from the committee members? Any public comment? Okay. Angela, please do a vote by roll call.
Okay, a yes vote will be to approve the minutes as they are written. Hangley Doe is absent. Wendy Hatch.
Approve.
James Moore.
Approved.
King G.
Approve.
Kathleen Thompson.
Approve.
With a vote of 4 committee members, the minutes will be approved and posted to our website as written.
Thank you, Angela. Item number 6, I would like to invite the Department of Consumer Affairs executive staff to present their update.
Good morning. Is this on? Can you hear me? My name is Brianna Miller. I'm with the Department of Consumer Affairs Office of Board and Bureau Services. And we have submitted a written statement. However, I'm happy to read it to you all if that's what you would prefer. It's up to you. If you'd like.
If you wouldn't mind, that would be great.
I'll
Thank
go
you.
ahead and read. So pardon me for reading a letter, but that's what I'll go ahead and do. So the letter starts, "Thank you for this opportunity to submit a written update from the Department of Consumer Affairs to the Professional Fiduciaries Bureau. You will find below an update on recent activities of the department. First up is the Director's Quarterly Meeting. Chief Deputy Director Chris Schultz hosted the DCA's Director Quarterly Meeting on June 3rd. During this meeting, he communicated his commitment to ensure a smooth transition as the Governor's office continues to search for a new DCA director. During the interim period, he encouraged executive officers and bureau chiefs to send ideas regarding cross-cutting projects where new leadership and the administration can focus. Next up is mandatory sexual harassment prevention training. 2019 is a mandatory sexual harassment prevention training year for the Department of Consumer Affairs. This means all employees and members are required to complete this training this year, even if it was completed last year. The department would like to achieve 100% compliance for managers and supervisors, including board and committee members. This training is online and can be completed at your convenience. Next up is the Future Leadership Development Program. Application deadline for the third cohort was August 13th. This cohort is scheduled to have its kickoff meeting in September. We look forward to announcing program participants at the next committee meeting. If you have any questions about the Future Leadership Development Program, please feel free to contact the DCA Solid team. And that concludes the update. Thank you again for your valued partnership. Please let us know if the department can be of service to your bureau. And if you have any questions, Deputy Director Christopher Castrillo offered that you may contact him.
Thank you so much. We'll be sure to disseminate the report to the advisory committee members, and then we can also host it up to the website.
Great.
Thank you.
Thank you.
Thank you. Any comment from the committee members? Any public comment on item number 6? Thank you, Ms. Miller. Item number 7, I would like to invite the Department of Consumer Affairs Budget Office to present the budget update.
Good morning, Chair Thompson, Chief May, committee members. My name is Paul McDermott. I'm from the Department of Consumer Affairs Budget Office, and I'm here to discuss the budget as is and go over any questions once we go over it. Two things we're going to look at, as we did from last time. I have two documents that I refer to. It's going to be the one is the expenditure document, and it'll be the first one we talk about. The second one will be the fund condition. Okay. Since our last meeting, there has not been any changes in the way in which the Bureau has handled their expenditures. I look at two things. I look at revenues coming in, I look at expenditures going out, just like any business. In the case of the Professional Fiduciaries Board, we are bringing in more than we are spending. So great job in keeping the expenditures down and staying in the positive. Right now, we have a governor's budget of about $562,000, and we're projected year-end to be about $507,000. About 508, excuse me. And right now, we haven't closed out FM 12 yet. We're finalizing everything, going through some liquidations, and it shouldn't be much change. We have all the expenditures captured, so there'll just be a little bit of a change as we meet next time, but we'll have more solid numbers at that point. If we go to the second document, which is the fund condition, this is a document that will show your revenue streams, which is the top half, and then we'll subtract out the expenditures that I pulled from the expenditures received. So our expenditures, our revenues for 2018-19 is about $560,000, and we're looking about the expenditures of $562. It's going to adjust off of this, so we'll handle that. But if you look down at the bottom, we have months in reserves. That's the amount of money, months of money that you have in reserves in case California stops doing business right now, and you have months in reserves to handle your operation, your daily operations. So about 3 to 4 months is a pretty solid. That's where we want to keep most boards. So that's a good reserve to have, and have no concerns about that. So all in all, nothing has changed. Everything has same as last time, and we'll have more definitive numbers as Fiscal closes out their FM13 for 18-19. Any questions?
No? Any comment from the committee members? No? Okay. Any public comment on item number 7?
Good morning, Richard Calhoun with Cedar. I'm looking at the analysis of the fund condition. I'm looking at line number 412-7400, renewal fees. It's listed as $454,000. My understanding is the renewal fee is $700. You get there by multiplying 700 by 649, but the Bureau claims to have about 750, 760 licensees. Why are we 100 short without paying renewal fees?
So in the first year, some of the licenses are issued for more than 1 year in the first year, and many of them are, because there is a prorated to the birth month of the second year. So I believe, I just did statistics, I believe that we issued about 80 licenses, so that's possibly what it was. We also may have had some people that went delinquent during that time, so that's the explanation for that.
Where do they show? If you have 80 people that are paying more than $700, that would be more money. If you're saying they paid the previous year, the people that paid the previous year, this year would be showing up. It doesn't add up. There's money missing.
I think there was another person that wanted to make a public comment.
At the meeting in LA in January, there was an advocate down there who asked if perhaps the PFB should consider requesting additional funding to better handle investigations, better handle complaints, better respond to those matters that are of great concern to the public. And the answer came back, I think from Ms. May, that no, the budget is fine. PFB doesn't need any additional money to do investigations, to handle complaints, citations. It's just okay. But considering that the PFB has never in its entire history issued a single citation for abuse of a client, and at the last couple of meetings, the PFB can't even define what would be considered a violation of a license, it seems that there may need to be some additional funding in this area, and certainly some additional expertise on what is appropriate behavior under a license, what does constitute a violation, what should require the PFB to issue a citation. So I think it might be appropriate to include those matters in budget discussions.
Thank you. Item number 8. Thank you, I'm sorry. Item number 8, I would like to invite the Department of Consumer Affairs Legislative Review Office to present the legislative update.
All right, good morning, folks. My name is Alex Mellington. I'm a legislative analyst with the Department of Consumer Affairs Division of Legislative Affairs. As always, I'm kind of a low talker, so if I'm not talking loud enough, please let me know. I'll try and move as close into the microphone as I can. I'll start off by giving a rundown of some of the approaching, or in this case, deadlines that have already passed. Between now and the middle of October is sort of the home stretch for the legislative calendar. On August 12th, the legislature reconvened from its summer recess. So as of Monday, it's back in session. And on August 30th, The last day will elapse for fiscal committees to meet and report on fiscal bills, and in parentheses there, this is also known as the suspense hearing. Bills that have a fiscal cost associated with them are on a special review track, and this August 30th deadline is the last day for those bills to pass out of the Appropriations Committee, and that is the committee of the legislature that deals with matters involving spending money. September 3rd through the 13th is designated for floor session only, so various matters will occur in both houses, the Assembly and the Senate, including votes on bills that are pending. There may be limited amendments to bills at that time. September 6th, there you go, is the last date to amend bills on the floor. September 13th is the last day for any bill to be passed out of the legislature. And then finally there, October 13th is the last day for the governor to sign or veto bills. The next item is 2019 legislation related to the Bureau. As in previous updates, there is no legislation that is directly related to the Bureau. All of the other legislation is in the item following below, and that is other issues. To start, most of these descriptions are the same as the descriptions that were offered in previous updates of this at this meeting. I've put in bold information related to amendments to bills that are still pending, and I've put in italics current statuses of the bills. Now, there's a couple of these that are a little bit different. I had to prepare this handout a couple of weeks before this hearing, so I'll give a rundown based on today's information of these bills. 473, AB 473, would increase the specified dollar amounts for a small estate to qualify for disposition without a full probate administration. I'm going to try and keep these descriptions short because they're going to be the same as they would have been otherwise. This bill was enrolled on July 9th and was actually chaptered on July 30th. So it has now been signed by the governor and passed into law as of July 30th. AB 1378 would authorize a custodial parent or person who has been awarded custody or guardianship of a minor child to designate a person to serve as a standby guardian of that person, the estate, or both by completing a standby guardian's authorization affidavit. This bill failed its first policy committee deadline and is now a 2-year bill. So the legislature works on a 2-year cycle. This is the first year of that 2-year cycle. If you have a bill that for whatever reason does not make it to a final vote, you can opt to allow that bill to fail any one of a number of legislative deadlines, and that bill presumptively becomes what's known as a 2-year bill, meaning that you can't do anything else on it this year, but you can go ahead and try again next year. AB 1396 would authorize a court to order a restrained party to participate in mandatory clinical counseling or court-approved anger management courses when the court issues a protective order for abuse involving acts of physical abuse or acts of deprivation by a care custodian of goods or services necessary to avoid physical harm or mental suffering. This bill was amended in early May to specify that each county adult protective services agency would be required to develop and provide information on elder abuse prevention and services. And finally, this vote is pending on the Senate floor. Checked again this morning, it is still pending vote on the Senate floor. AB 1572 would have changed the definition of gravely disabled in the Health and Safety Code. The description of those changes are followed below. But the bill's hearing before the Assembly Health Committee was canceled at the request of the author, meaning the bill is effectively dead for this year. Again, it could be brought back next year. SB 303 would change existing guardianship conservatorship law, which allows the guardian or conservator to establish the residence of a ward or conservatee at any place within the state without the permission of the court. and requires the guardian or conservator to select the least restrictive appropriate residence available. This bill would instead provide that a presumption about where that residence is to be overcome by clear and convincing evidence. This bill was amended on July 11th to prohibit the compensation of a guardian, conservator, or attorney with any government benefits program monies via court order under Probate Code Section 2640 unless it is deemed necessary by a court to support and maintain the ward or conservatee unless otherwise permitted by law. And just for reference, Probate Code Section 2640 refers to the manner in which the petition for the court order can be made. So it's a lot of words saying, if you ask for a court order issued under that probate code section to allow the disbursement of government benefits program monies, you must also make a showing, and the court must also rule that it is necessary to support and maintain the ward or conservatee. This bill is also pending a vote on the assembly floor. This bill actually, and when I checked this morning, this bill passed off of the floor on Monday when the legislature returned and was sent to what's called concurrence for a vote tomorrow. So when a bill is, when it passes out of the first house and is subsequently amended in the second house, those two versions of the bill no longer match. And so it has to go to a final vote known as concurrence so that everybody can agree that the final version of the bill is the one that they would like to pass. And that's where it is now. So it's just a little procedural wrinkle on that bill. SB 308 would revise the definition of instrument under the probate code, and the description of how it changes that is below. That bill was chaptered on July 1st, so that is now effective. Well, it will become law as of January 1st of next year. SB 314 would extend the remedies under the Elder Abuse and Dependent Adult Civil Protection Act to cases in which the defendant is liable for abandonment under existing legal standards for physical abuse or neglect. And this bill was chaptered on June 26, 2019. SB 338 would eliminate the duty imposed on long-term care ombudsman programs to revise or include in their policy manuals specified information regarding elder and dependent adult abuse. This bill was amended on June 17th to include a requirement that any written law enforcement policy include protocols for cooperating and collaborating whenever possible with the Bureau of Medi-Cal Fraud and Elder Abuse and other agencies. So pretty much, if you have a written policy on this and you are a law enforcement agency, then your written policy should include protocols for cooperating with other state agencies. Finally, SB 496 would expand the category of mandated reporters of suspected financial abuse to include broker-dealers and investment advisors. This bill is pending a vote on the assembly floor, and last time there was a question raised by Ms. Thompson about when exactly a broker-dealer or investment advisor would be allowed to delay the disbursement of funds. This bill also does that. And I've provided a written answer here indicating the circumstances under which a transaction may be temporarily delayed. And just very briefly, I won't read you all that language there, but there are 4 criteria that need to be satisfied. 1, whoever's doing the delaying needs to have a reasonable belief based off of an internal review of the transaction that the transaction may result in the financial abuse of an elder or dependent adult. They must, within no later than 2 business days, provide written notification of the delay and the reason for that delay to all parties involved, unless that party is reasonably believed to have engaged in the financial abuse of the elder or dependent. Also within 2 business days, the entity delaying the transaction must notify a local county adult protective services agency, a local law enforcement agency, and the Department of Business Oversight about the delay. And finally, if you delay the transaction, you have to provide updates relevant to the report to the local adult protective services agency, law enforcement agency, and the Department of Business Oversight. That's it.
I may have missed it, but what is the status of SB 338?
It's pending a vote on the assembly floor.
Okay, so it's still pending.
Yes.
And SB 496, that's still pending as well?
That is also pending, yes.
Okay, thank you. Any comments from the committee members?
This is King G, and I have just a request for clarification on AB 1396. Once the party that's restrained completes the counseling courses that are mandatory, do they revert back to their duties after the completion, or is there a period beyond the counseling?
I can't give you a 100% answer, but I believe that it would be dependent on the order. So it wouldn't by default end the restraining period by completing the courses. It would be like an additional requirement. But I can definitely look into that for you.
Right, because once they complete the course, I'm not quite clear whether they resume their duties as a conservator or guardian or over the abused party.
And I would imagine that probably depends on the nature of the individual court order and the nature of the basis for restraining the party. So I believe it would be within the court's authority to indicate what conditions would be satisfactory for terminating the restraining order. And I don't know. It may be time-based, it may be based on meeting certain conditions, but I can definitely look into that for you.
Thank you.
Yes.
Wendy Hatch, I have a question. I think Kathleen brought it up last meeting, and I don't recall your answer on AB 1378. Was there a statutory time that the standby guardian was going to be assigned, or was it going to be continuous? What was the
If I recall, I think what I said was, I believe it depends on the nature of the need for the standby guardian, that yeah, there's a standby guardian's authorization affidavit, and it may be that, I might have to take a look at the statute again, but I believe that the standby, you can be designated as a standby without time limitation, because the designation is based on what if this happens, then you have the standby designation. But if you become the active person, then that might be limited in time to the circumstances that gave rise to your activation. So if, for example, a person, a custodial parent or guardian has died, then that might be continuous. But if a custodial parent or guardian is detained by law enforcement, is incarcerated, or is deported, that might be time limited, and there may be an order establishing the time period for which you would have active authority.
I apologize for my naivety, but what court is issuing these orders? Is it the probate court, or is it civil or family court?
That I do not know. I kind of would have to look that one up for you.
Thank you.
And I'm confused by this as well. I still am concerned if there is a guardianship and the guardian has died and signs this affidavit before they pass away, that this now assigned guardian, there's no vetting of the guardian, there's no court order of the guardian, there's no notification to the court. So I'd be curious to know how they are dealing with that.
think those are
Yeah.
valid questions. And, this bill is now a 2-year bill, so it is no longer proceeding.
Okay.
Certainly, I can look into all of those questions and provide additional guidance on it, but there's no further action to be taken on it this year. And just as a general matter, I unfortunately am not a subject matter in the probate code or the operations of courts that oversee guardianships. I generally assist the department and the Bureau in questions related to the operations of the department and the Bureau. So I can try and offer interpretations of the probate code where I've seen stuff before, but I may not be the best party to get that clarification through.
Understood. We're putting you on the spot here, too. so.
And if I could just chime in with one thing, we'll know early next year if it looks like this bill is
Okay.
moving again. So
Okay.
it won't be a surprise.
All right. Thank you. Any other comments from the committee members?
I have one more question. It's King G again. SB 496 on the mandatory reporter. There's a 2-day delay. Is that the way it reads, if there's suspicion of abuse?
So I may have
For the
lost it in my synopsis there, but the requirement of reporting to a third party is immediately, but no later than 2 business days. So the answer to your question would be yes, you would have as much as 2 business days to notify the required parties.
So
If you delay a transaction.
within 2 days of the transaction coming to your attention?
So it would be within 2 days of your delay of the transaction. So a request for a disbursement of money might come in, and you would conduct an initial review, and at some point during that review, you would decide to delay the transaction, and upon your reaching a decision, that is when the 2 days would begin, so within 2 days of that decision.
So when it's turned over to the appropriate authorities, then how long does that take place until, is that disbursement rendered suspended until the resolution of that?
I would have to take a look at the bill's language. I believe the answer is that they're not dependent on each other, but it is a temporary delay. I'm not sure exactly whether it's a delay that is of a certain number of days or a delay that elapses on the occurrence of certain independent conditions.
I guess my question is, how long
Right,
How
long is
long?
the delay?
does a party that receives the temporary delay for disbursement, how long do they have to resolve that matter before? Because there are people out there that are waiting for payment, and if it's not resolved, is that suspended until that is resolved?
So the bill actually does indicate a maximum timeline, and there are a couple, the longest of which appears to be 25 business days after the date on which the mandated reporter first delayed the requested disbursement of the transaction.
Okay,
So there is a maximum deadline.
So if it's not resolved by that period of time, then the transaction takes place?
A court of competent jurisdiction may enter an order extending the delay of the requested disbursement or transaction, or may order other protective relief based on the petition of any adult protective services agency. So there seems to be a more nuanced way of handling whether a delay will be concluded going forward. Sometimes it might just occur by operation of law on a certain number of days elapsing, or it looks like a court may issue an order extending the delay if it looks like there's a pending investigation or a petition of some other reason from an adult protective services agency.
Okay, thank you.
Sure.
Any other comments from the committee members? Any public comment?
Richard Calhoun with Cedar. Regarding SB 303, what is this board doing to educate your licensees who have been using Social Security benefits and other benefits to pay themselves for the last umpteen years? It's against federal law. We had to come in and now pass SB 303 to put it in the California probate code. It wasn't in the probate code because it was in violation of federal law. So you conservatives up and down the state have been violating federal law for the last decade, and your board hasn't done anything to educate them from what I can tell. We can go back to AB 937 in 2013, the exact same thing. You never can isolate someone. Your licensees up and down the state were isolating them. We had to go in and specify in the probate code that control does not go to personal rights. In the mission statement, we hear that at every single meeting. Let's start educating your licensees on what they can and cannot do. They are completely out of control in this state.
Linda Kincaid, also with Coalition for Elder and Disability Rights, and I should add that we were the sponsors of SB 303. The synopsis here in the handout for SB 303 is pretty far afield from the actual text or intent of the bill. As Mr. Calhoun stated, the original text of SB 303 was simply to protect federal benefit payments to the conservatees, such as Social Security. The bill came out of a case in the East Bay where a licensed professional fiduciary was seizing a conservatee's Social Security benefits to pay the conservator and to pay the conservator's attorney, rather than using those funds for the care of her client, the conservatee. We approached Senator Wajkowski. SB 303 was the result of that discussion. It was amended along the way to also include the personal residence. So the goal of this SB 303 is to protect the federal benefits and the personal residence from predation by conservators and attorneys. And I would like to read a few sentences from the legislative analysis that I think would be very enlightening. A conservatorship is the only profession that grants a service provider unfettered access to client assets. Conservators use client assets to fund litigation against the client and against the client's family. Multi-million-dollar estates are depleted by legal fees, while conservatees languish in substandard facilities. In 2006, the legislature passed the Omnibus Conservatorship and Guardianship Reform Act, a landmark package of bills to overhaul California's troubled conservatorship system. That legislative package was designed to remedy alarming deficiencies in California's conservatorship system that had resulted in abuses of California's elderly and most vulnerable. Unfortunately, the important new court oversights in AB 1363 were never funded, and as a result, are not mandated today. So I would like to ask the PFB what you can do as an entity to start protecting conservatees. The courts never got the funding that they needed. There are many parts of the probate code that are not implemented because the legislature has not funded those pieces of legislation. What can you as an entity that I hope has some interest in the welfare of the elderly and disabled, what can you do to start to provide some oversight and some protection for the people who are being abused and their estates plundered?
Well, we've said at previous meetings that we do not oversee the probate court, and we cannot overturn court decisions or enforce court orders. Thank you.
I would ask that you start overseeing your licensees.
Hello?
Committee and members, my name is Jerry Desmond, and I'm here on behalf of the Professional Fiduciary Association of California, PFAC. I was just going to add our own comments on SB 303, the Wajkowski bill, following up on what Mr. Millington said in terms of the provisions of the bill. I think it was at the last advisory committee meeting in May that we reported that PFAC had a neutral position on the bill as it was amended on April 30th. The provisions provided what we think are, of course, the appropriate emphasis on the protection of conservatees and their best interests. That's paramount in what we do as licensed professional fiduciaries, and I think that's paramount in the bill itself, SB 303. The role of the courts, we think, and the probate courts is fundamental, and we realize that the bill provides for a role of the courts and determinations in regards to both personal residences and as well as the compensation of conservators and guardians. As the bill was amended, emphasized by Mr. Millington in the report here on July 11th, we continue to have a neutral position on the bill, and so we are not opposed to SB 303 since it was amended on April 30th, and as it moves forward towards the governor for enactment into law. Thank you.
Thank you. All right, thank you. I think that concludes this.
Thank you very much.
Item number 9, Rebecca, please present the Bureau updates.
Thank you so much. I'll start with the licensing statistics. You're welcome to follow along with me in the packet. So these statistics represent our numbers from July 1st, 2018 through June 30th, 2019. We have 67 new licenses, 756 active licensees, 1,118 total licensees from the first licenses that we issued in 2008, and 119 new applications. For complaints and discipline, same time frame, July 1st, 2018 through June 30th, 2019, we initiated 5 cases with the Attorney General. We issued 14 citations. We have received 126 complaints. We have closed 74 complaints. We have 69 complaints pending, and the average days to close complaints is 132. For our outreach events, we haven't had any since the last advisory committee meeting, but we have a couple coming up. We have on October 16th, the Yolo County Senior Resource and Crime Prevention Fair in Davis, and on the 19th in Dixon, the Dixon Senior Resource Fair. If there's events that you'd like the Bureau to perhaps attend, please contact us. And as for the newsletter, I think we're getting into the rhythm of twice a year, at least that's my hope. I'm hopeful to have another one out by our next meeting. And of course, submissions, especially from our advisory committee members, are always welcome. And if there's something in the newsletter you'd like to see, please just let us know. Thank you.
Any comment from the committee members?
Wendy Hatcher. Rebecca, the 67 new licensees, are they part of the 119 new applications, or we still have 119 still pending?
So we don't actually have the number of pending applications on here. Sometimes the process can take 3 months, and some people take a year or more to complete the process. So their applications may have been received in the same fiscal year and they licensed, but they may not have.
Kathleen Thompson, the 1,118 total licensees or licenses, I assume that those include retired licensees, or because the numbers, new licenses and active licenses obviously don't add up.
Sure. That's the number of total licenses that we have granted since the initial start of the Bureau.
So that includes maybe licenses that were revoked or
Right,
retired
retired.
or, okay.
We don't officially have a retired or an active designation. Right now, it's active, delinquent, or canceled at a certain point. We're working on regulations for inactive and retired licensees right now.
Okay.
Wendy Hatch in here. Reviewing the record, so counting the 67 and the 756, so in this fiscal year, we should have collected over $700 from 823 people, correct?
Yes.
No, these are sorry. The licensing statistics are new licensees. So they pay, their first year is $600 plus a prorated fee to their second birth month from the issue date. No license can be issued for less than 12 months or more than 24. So they pay $600 for the first year plus the proration. So it's going to be a different amount for each person who's newly licensed.
I'm just going back to the budget and kind of following up on Richard's question. I just don't, because it might even be more than the 700 for these, so.
So we have, I was thinking about this ever since Richard asked the question. So when we issue a license, it may have been issued at the very end of the last fiscal year. So it could have been issued like June 25th of 2018, but it doesn't renew for this whole fiscal year, and it'll renew in this current one. So even though we're renewing less licenses than are active, it's because we renewed about 600 and something licenses last year, but some of them don't renew for more than a year. So they've issued the license, but it's not going to renew for more than a year. So it's not counted in the renewals at that time. Does that help?
Kathleen Thompson, on the complaint statistics under complaints closed, is it possible to get kind of a breakdown of how those cases were closed, or were they all closed because they were unfounded, or?
Well, we would close them once we either find that there is no wrongdoing, or we're not unable to take action, or there has been disciplinary or administrative action. Those would be closed as well.
Would it be possible to get a breakdown? 10 went to an administrative action and 64 didn't?
Yeah, I think that's data we can supply at the next meeting.
Okay, thank you.
Again, Wendy Hatch, following up on Kathleen's question to Rebecca. So if we take the AG cases and the citations, that's 19. And if the complaint closed for the fiscal year of 74, so there's 55 cases that, there still might be pending. So some of this 55 might be in the 69, but of this 55, some of them were closed because of not finding any complaint?
I'm sorry, can you repeat your numbers?
Sorry. Okay, if you take your AG cases initiated and citations issued, well, no, I guess we can just take the 14 because the citations issued are cases that are completed and closed out, correct? So,
Well, some do become AG cases after a citation has been.
so in this fiscal year, the 60, if you take the 14 from the 74, the 60 cases, some of those 60 cases are still in the 69 pending, and some of them might be closed?
Yes. Yes, and some may also be, from the previous fiscal year that were still open.
Okay.
Any other comments from the committee members?
Yes, this is King G. I have a question on the outreach of events. If we do have some from, say, an influx of events in Southern California, does our current budget allow for travel to those events by staff?
Quite possibly, yes. Yeah, we are always trying to make sure that the budget is lean. I know we're a little more in the black than usual because I went on maternity leave, which suggests how small the budget is, that would actually make an impact. So there may be some more, as long as our bottom line adds up, it's okay to, to move in between those budget categories.
Because the last time I remember in the makeup of the licensees, half of them were in Northern California roughly, and half were in Southern California. And to see that there aren't any outreach events in Southern California, and should there be some, and there should, then I was curious whether staff had the resources to be there.
Yeah, I agree, and if we can move resources to travel more, then we would.
Also, if you're aware of any that we
Yeah.
should attend, that would be great, because nobody reaches out to us with them. We have to kind of find them.
Okay.
Any other comments from the committee members? Okay. Any public comment? No?
Linda Kincaid, Coalition for Elder and Disability Rights. I have another complaint, and I know that you like to keep complaints secret, so I won't disclose the actual complaint, but I do have a cover letter that I'd like to read. It begins with, "Is killing a client a violation of the Professional Fiduciaries Bureau license? In past meetings, you stated that most complaints against licensed professional fiduciaries are complaints about care, but the PFB has never cited any licensee for any issues related to care. Your responses to our prior complaints established that the PFB is not considering the following actions to be violations against the license: false imprisonment, forced isolation, mental abuse, physical abuse, conspiracy to commit elder abuse, forgery, and fraud. Like the PFB, Florida's Office of Public and Professional Guardians receives many, many complaints about professional guardians. Like the PFB, OPPG failed to protect the public from predatory guardians. On August 9th, 2019, ABC reported resignations of 7 of 11 members of Florida's OPPG. And now I'm quoting from the article from ABC 7. The majority of those resignations came after an I-Team report in July about an embattled former professional guardian, Rebecca Fearley, who is under criminal investigation for accusations she caused the death of a man under her care by issuing a do not resuscitate order without permission. The California licensed professional fiduciary in the attached complaint went beyond allowing her client to die. The California licensee directly caused the death of her conservatee. Back to our initial question. Does the PFB consider killing a client to be a license of the fiduciary's license? And I will hand in this complaint.
So as we've said previously, the Bureau is not a law enforcement agency and does not have the authority to conduct criminal investigations. If a complainant has evidence that a licensee has been convicted of one of the crimes you mentioned, please submit that evidence of conviction to the Bureau. If you believe a crime has occurred, you should contact law enforcement to submit those allegations.
That would seem to imply that the PFB will allow such persons to continue with impunity for the years that it takes to work through the criminal justice system and get a conviction if indeed law enforcement actually responds.
So we don't have the authority to immediately remove a license merely upon the receipt of allegations of wrongdoing. If there's a conviction of a crime, please send us that information. Thank you.
Thank you for confirming that you do nothing until there is a conviction and you let people operate who have done horrible things, and unless they're convicted, it's all okay with you guys. Thank you for that confirmation.
Thank you so much.
All right, thank you, Rebecca. Item number 10. Rebecca, please present the status of the Bureau's proposed rulemakings.
Thank you so much. So unfortunately, none of these seem to be moving any more than they were last time we were here. The first two in the agenda, the first two rulemakings regarding the inactive and retired license regulation and the client notification regulation, those are pending in the Department of Consumer Affairs pre-approval or pre-review process, and they're with the legal office, is my understanding. The third one is regarding advertising, and that one is also, that one's on hold pending the last one, which is the implementation of AB 2138. And my understanding is that one's with legal as well.
Madam Chair, that is correct. The first and second regulation is still pending review within my office, as is the fourth one.
Thank you.
So as soon as any of these move, we'll certainly let you know.
All right. Any comment from the committee members? Any public comment on item number 10? right, thank you. Item number 11, Angela, what items have you recorded from our meeting today as future agenda items?
So I've recorded three different items that were brought up as possible future agenda items. One was a budget discussion on whether or not the enforcement budget needs to be increased. The second was clarification on AB 1396 of when the standby order terminates. And there were a couple other things. I'm going to have to listen to the recording that would be included in that as well. And then finally, a breakdown of the types of closed complaints. Is there anything that I missed from the committee?
I don't believe so no? All right, no comments from the committee members. Okay. Is there any public comment?
Yes, at the last meeting, I asked if you could set an agenda item to discuss the mission statement and perhaps starting to implement that mission and perhaps even training your licensees on the mission statement. And I'd like to go back and read it again. To protect consumers through licensing, education, and enforcement of the Professional Fiduciaries Act by promoting and upholding competency and ethical standards across the profession. I will again ask that at some point, this competency and ethical standards become a part of your mission of what you do, start training people on it, and start acting appropriately. Thank you.
Richard Calhoun from Cedar. Let's go back to November of 2018. There was a whole lot of requests for future agenda items. They still have not been agendized. In January, there was a whole bunch of requests for future agenda items. They haven't been agendized. The same for May, and now we have August. When do these future agenda items ever make it onto the agenda? The public has been asking for information about complaints. What is a complaint? How do we have to file it? I think I filed about a dozen complaints. I haven't had a single confirmation that you've had any of my complaints. There's a huge gap. The public doesn't know what's going on. You think you're transparent. We don't have a clue. We come to these meetings, we ask for future agenda items, and they don't happen. What is going on?
All right. Any other comments from the panel here? No? Nope. Thank you.
I'm Michael Storrs, the president for the NorCal region for PFAC. And in terms of education, you know, I'm also the chair for the Center for Fiduciary Development. So in terms of education and getting the word out, we offer our resources to aid the Bureau in helping get the word out.
Thank you.
All right. Thank you. Item number 12, the following dates have been selected and scheduled for the remainder of 2019. If you have any conflicts with these dates, please contact Angela Kudrow. And the date is Wednesday, November 13, 2019. Any comment from the committee members? No? Any public comment?
In years past, you used to hold satellite locations for your meetings so that members of the public were actually able to participate without coming to Sacramento. And that was certainly nice for people who live in Los Angeles or San Francisco, and it's not convenient for them to spend a day, 2 days traveling to Sacramento to come and express their concerns here. As soon as people started appearing in San Francisco and in LA and expressing concerns, complaining about issues, suddenly all of those satellite locations were terminated. Now, if anyone wants to submit any public comment, they have to take time out of their lives to come all the way to Sacramento to be here for this meeting. Are you ever going to start having other places throughout the state where the public can participate and make comments?
We can certainly consider it. At present, we don't have any members from the Bay Area or from Los Angeles. So that's why we are having our meetings in Sacramento exclusively at the moment.
All right, thank you. Item number 13. The committee would like to briefly address public comment for items not on the agenda. The public comment for items not on the agenda section is a time for the public to comment on items that are not listed on today's agenda. To allow the committee sufficient time to conduct its full schedule of business, public comments will be limited to 2 minutes apiece. There are a few other rules that apply. First, California law prohibits committee members from discussing or commenting on any matter brought up during public comment for items not on the agenda. Also, committee members are not allowed to take action on any item not on the agenda. If you want the committee to discuss a topic not on the agenda, you may ask the committee to consider placing that issue on the agenda of a future meeting. However, the committee is not obligated to fulfill that request. If you have an application, complaint, or disciplinary charges pending before the Bureau, or if you are about to bring a complaint to the Bureau's attention, please do not discuss the details of your case or complaint. That's because the Bureau's counsel reviews disciplinary cases and is not permitted to receive evidence or information that is not part of the administrative record in the case. The committee strongly asks that you also respect the privacy of others by not revealing the names and conditions of any individual involved in any case or complaint. In order to allow the committee sufficient time to conduct its full schedule of business, please do not duplicate or repeat the comments of a previous speaker. At this time, are there any members of the public who wish to address the committee committee or to offer an agenda item for a future meeting? I know that we already covered that.
Your new rules completely hamstrung the public. I submitted 12 complaints probably, and none of them got acknowledged. I was planning on talking about a complaint, but based on the new rules, I can't even do that. So here's a complaint, okay? See it? Documentation, I won't tell you the nature. It's an AG complaint that's already on file by somebody else, and it follows the same thing. It's also financial felony elder abuse. You guys need to wake up and pay attention, because I could duplicate that for every single one of your licensees.
All right. We're going to adjourn this meeting, and the time is 11:07. Thank you.